Andras and panelists, the floor is yours.
Welcome back, everyone. I see that we are diminishing in numbers, but these are the resilient ones here. I'm very happy that we still have people in the room, but it will be worth it because we are going to talk about policy and regulation. And this is quite a controversial topic. And it's also very, very interesting to see what regulators and what policymakers, governments can do and what cannot they do. And of course, I'm not trying to pick on anyone, but this was the easiest symphony to choose because it's called the Unfinished Symphony, but I will stop there. But we will start with Jonas first, who is representing the European Commission, and then after him we have Jamie from the UK IPO, we have Wei Jiang from SNIPA, we have Chris from USPTO, we have Yoshinobu from JETRO, JPO extension, and we have Alfred from Singapore's IPOS. So I welcome all of them, and I hope at some point we can have the background slide up there so that you can read the full names and affiliations. Thank you very much. So let's talk a little bit about what initiatives or activities your government, or in Jonas's case, your institution, has done or plans on doing in the area of standard essential patents, and what are the next steps envisaged. Now, obviously, all the speakers have different perspectives because they are coming from very different institutions, very different regions of the world. So it will be particularly interesting to hear what those institutions, what those IP offices and other government agencies have been doing, have been up to, and planning on doing. So, Jonas, please tell us a little bit about the lessons learned from this legislative initiative that the Commission has launched a couple of years ago, and what are the next steps there?
Happy to. Before I do, I'd just like to say, Andras, thank you very much for organizing this event, and thank you to Nina. It has been incredibly insightful, fantastic to meet many people, and actually I was thinking that had we not withdrawn the regulation, many of the things that I learned here today might have been really helpful in the process. So I thought that instead of maybe communicating to you the official line of the Commission on the withdrawal of the proposal, I would maybe engage in some thinking about what kind of lessons we learned from this proposal since it was communicated that we would want to withdraw it in February of this year. And essentially, and I should say that all these views are my own and in no way reflect the official position of the Commission. I think there's three lessons that I would draw, at least preliminarily, from this exercise. And the first is that you shouldn't underestimate the time complexity function connected to SEP's legislation. You all know that in April 2023, the Commission presented a patent package that included a number of different initiatives that covered different markets, different objectives, different stakeholders. And while this did help to build a broader narrative around patent policy, both outside of the Commission, but also inside of it, it also overwhelmed stakeholders and institutions. And this, we observed, led to parallel substantive debates. It was ailed by understandable, I think, attention deficits and recurring focus shifts. And we felt that the legislative process was not capable of devouring the complexity that was presented to it in an efficient order with respect to the SEPS regulation. And moreover, this was observed, wittingly or not, by many observers in a way that belied the fact that none of the texts that were in the public domain would be probably remotely comparable to the final negotiated outcome that was yet to be negotiated. They argued, in my perspective, often as if the proposal was a foregone conclusion, which indeed it was not, and it moved, I think, the focus away from substance and potential compromise solutions. And on the other hand, I think an issue that the complexity really had here was that SEPS really sits, and we've heard this in a number of panels today, at the crossroads of a number of different legal areas, so antitrust law, contract law, we heard it, telecoms, trade, industrial policy, and that really means that you need to have communities, even in the institution of the Commission, to see eye to eye on the solutions to the problem, and that's not always possible. And in fact, we heard early today in the first panel that the DMA might have been an example of what could have been done, but that would have required a similar view on the antitrust perspectives of the SEPS issue, which you all know from Article 1 of this proposal didn't exist. And additionally, I think an issue with SEPS and its complexity, and specifically in Europe, is that it has become, the standardization landscape has become particularly polarized. In general, companies, specifically European companies in this space, generally confront each other in negotiations and in court proceedings, and not in cooperative environments. There is only 1 to 3, depending on how you count it, implementing EU companies amongst the top 40 5G contributors in 3GPP. And I think this really has shaped the environment and atmosphere of discussion. And so I think with this significant delay in timing and this change type of context, the perspective of the proposal really changed, politically, economically, and legally, and what might have been possible in 2023 really wasn't possible anymore to convince the relevant institutions in 2025. A second lesson that we draw from this is that a political institution really needs to stay the course, communicate a clear vision, and enforce realistic expectations in the light of complex regulatory matters such as SEPS. The proposal really was an example of, is my observation, of legislation in our era, where the antagonization of the opinion space and the reduction of what could be constructive substantive discourse really leads to more personal frustrations and zero-sum strategies. And I think that government needs to react to that in 2 different ways. And the first is really communicate a clear vision of what you're trying to achieve, stick to that, and also show where flexibility and substance does exist. And our objective was actually, in my view, very clear. We had an interest in a strong, innovative, cost-effective, global open standards system, and in more comprehensive participation in that standardization ecosystem. However, when we looked at the facts and the SEPS market, we saw that that was characterized by a lack of trust of its participants, lack of predictability, forum shopping, and just overall pervasive discontent. And so I think that no matter how you look at this market, and no matter what side you stand on, I think it's clear that those are not market conditions that will sustainably deliver reliable growth, future revenue, and innovation along the entire value chain. And so we think that we thought that SEP's policy really needed to streamline licensing, not as a sanction to any one side, but to instill trust amongst the key stakeholders, precisely because we thought that this was in the broader interest of the EU and the broader interest of the standardization system. Because trust reassures new entrants in implementing markets, and then reduces obstacles to widespread adoption, and then increases revenue on the side of standardizing companies. I think this objective that we had was valid. I think it remains valid. And looking forward, I think we need to keep the focus on that objective and maybe clarify where there is flexibility and also where there really isn't. And I think that brings me to the second point here, which is it's important also to manage expectations, which stakeholders, I think, need to come to terms with the fact that consultations in these processes is advisory, it is very important to us, but it is not a power-sharing exercise. Does that mean that we're oblivious to all the criticism that we receive? No, it does not, and it was not. In fact, as I said, the final product would likely have reflected many of the legitimate criticisms that we heard from the broad space of participants in the debate that we were very, very thankful for. But it doesn't mean that we would have adopted any one-sided view of this matter. And I'd like to say one third point, which is, I think what we need to take from this is that we need to embrace trade-offs and question determinacy. And what I mean by that is that it is surprising in this market that we can all agree on a lack of transparency, I think. Although it's a misnomer because we don't really know what that actually means, but in fact we can all say that there's a lack of transparency. If there is a lack of transparency, then two things follow from that. First is that if we don't have a market that delivers complete and full transparency, then there cannot be entire determinacy, entire clarity on the problem at hand. And yet the discourse, in my view, that we were confronted with in SEPS, it was often littered with a sense of certainty that I think belied the lack of information we had, at least with regard to policy developments. And so this would suggest, I think, to policymakers that we should approach absolute views with skepticism and lend credence to more nuanced views that disclose the presumptions they are based on. So I think that maybe just one final point. I think we have to understand that in a situation like this, in a market like this, there's not going to be a consequence, there's not going to be a legislative result that is going to be, or is going to be able to reconcile all different worldviews that exist in this market. That means that there's going to have to be a trade-off between unreconcilable perspectives. And that, I think, we really need to embrace as an entire community that engages the SEP space. And that's what I think is always interesting in these learned lessons, is that when you realize that the lessons you're learning, someone smart in history has already learned them. And I found this book by an American economist. His name is Thomas Sowell, and the book is called A Conflict of Visions. And what he says is that he explains the reason why political divisions are, he says, eternal, and that is because they are driven by irreconcilable visions and views of how human nature functions. And so he comes to the consequence, and this sentence to me is one of the lessons I learned. There are no solutions, there are only trade-offs. So I'll leave it at that.
Thank you very much, Jonas. Actually, I'm particularly grateful to you for these very candid thoughts. It's very rare to hear such remarks from an officer from an institution like the Commission. I know that these were your personal views, but I think it was great that you could share this with us. Thank you. Jamie, the UK IPO has also published something that is raising the attention or drawing a lot of attention to the members of this audience and, of course, also globally. It's a consultation document, and we would like to learn more about that and anything that the UK IPO is planning on doing. So the floor is yours.
Thank you very much. Again, just to echo the thanks for WIPO bringing us together today. We really do appreciate this time and the space to have such a meaningful engagement and discussion on these matters. So before I do get into specifics around what are we doing and what have we done, I think just to sort of build on some of the points which Jonas was making then about kind of the importance of innovation as well in this space. So I think it's worth me just mentioning from the UK's perspective really that we do have an ambition to make sure that the UK is a hub for innovation, and we have our government's economic growth ambitions and missions to accelerate innovation, investment, productivity through world-class science and research and development. And in turn, that also informs how we at the IPO develop our own mission to help the economy grow through the IP system, and that system should encourage investment in innovation and creativity. But, at the same time, we recognize there is an importance between the relationship of standardization and IP. And, I suppose those who participated today know this as well, but I'll repeat it. But standards can encourage innovation, enable jobs growth, and ensure interoperability for safety and quality of products. And the importance of SEPs in technical standards and the increased use of SEPs across industries in the UK, therefore we expect it to grow in the future as technologies develop. So in the UK, the IPO has responsibility for the IP policy and legal frameworks, as well as the enforcement and protection of the rights, but also we have a responsibility of the information at the Patent Office. And it's important that our policy development is as joined up with wider government on its missions and objectives as much as possible. And we do need to create an ecosystem in the UK which also recognises what is going on globally and at an international level. And discussions today are also really useful and really supportive of that point. Our task really as policymakers is to find solutions that take into account the needs of innovation and innovators in the UK and create opportunities for global collaboration and certainty for UK businesses entering into global markets. So if I just take it back then to what we're actually doing, so part of your question, what are we doing, what have we done? So just to be clear, we're not looking to regulate a market. So from the UK's perspective, what we want to try and do is increase information and understanding on SEPs and IP, but also for businesses and to offer options for industry to overcome the challenges such as transparency, which Jonas, you rightly raised, and information asymmetry and licensing frictions. And we've heard from many panels today about these matters too, which is really useful. But evidence is key to any intervention which the UK undertakes, and we're always gathering evidence. No matter how we look at it, we're using every opportunity possible to do that. So what's happened so far? In terms of the evidence point, we've been gathering evidence since 2021. We launched a call for views late in 2021, and then in mid-2022 we published the summary responses. It was approximately 106 pages of responses to summarising it, but that related to over 1,000 pages of evidence submitted to us from various parts of industry and business and academia. So we recognised there were some gaps within our evidence. So since that point in 2022, we've done a few additional activities to gather more evidence, particularly around SME impacts, and we launched a questionnaire in 2023 asking specific questions of SMEs, of how they operate within the standardisation space, which is really helpful and informative too. And we've continued around that, the stakeholder industry interactions, and continuously do that, and we'll always continue to do that too. We undertook independent research, and we're always looking to learn and understand these concepts and important matters such as redetermination and global comparisons. And this global comparison point is really important, as we hear today as well, to help the UK IPO colleagues who I'm here with today as well, to build our understanding. So all this evidence gathering related to a number of key findings, and I don't think our key findings are that much of a surprise really. The SEPs ecosystem is complex, incredibly complex. For that reason, we recognise the SEPs ecosystem cuts across patent frameworks, competition law, standardisation, as well as contract law. The judicial panel we heard this afternoon, really helpful. Our Lord Justice Mead eloquently put the position around the contractual approach which we take in the UK as well. But we do recognise it's a global ecosystem. SEP licenses can be granted to licensees globally, and this has resulted in several complex cross-jurisdictional disputes, including parallel litigation. So we also heard that the SEPs framework in the UK needs to strike the right balance, and I think that's something which we really certainly want to try and achieve, and that is making sure that the balance is for all interested parties. We want the UK to continue to be a forum of choice to resolve disputes and a location to innovate on standards, particularly for SEPs. Licensing generally takes place well in key technologies. That's something we also learned. But licensing frictions, information asymmetry, high litigation costs, inefficiencies remain and may deter businesses entering into standardisation, particularly for new entrants or SMEs. I've got a slide deck. I'm just going to try and play now, if that's okay. So this is where we're going to sort of move on to some of the kind of objectives which we've launched. So on the back of the findings, what we did last year in 2024, we published a number of objectives, and these 3 objectives are probably known, but it's worth me just repeating them again. And the first objective was to look at how we can help implementers, especially SMEs, navigate and better understand the SEPs ecosystem and fair, reasonable, non-discriminatory licensing. The second objective which we have is to look at improving transparency in the ecosystem for both pricing and essentiality. And then thirdly, achieving greater efficiency in respect to dispute resolution, including arbitration and mediation. We've been particularly incremental about how we're taking forward the initiatives around these objectives. So Since 2024, we've done a few non-regulatory initiatives. And I'm just going to quickly talk you through them. So if you're not familiar with them, you might find them quite useful. And earlier, very grateful. We know if you'd Nokia praising the Resource Hub, which is really, really helpful, and we are very grateful for that too. But we did launch back in July last year, first of a kind SEP Resource Hub. And this Resource Hub looks to address information asymmetries experienced by implementers, SMEs, and new entrants into technical standardization. The Resource Hub is also a resource where it provides information on licensing, FRAND obligations, dispute resolution, ADR, and we also provide a case law, up-to-date case law list as well, which we monitor and report for any UK SEP litigations. In addition to that, we've set out our work around SDO and engagement, clearly really important for us, and we are looking to collaborate, engage, and influence the IPR policies in the future to make sure fundamentally we can boost SME involvement into standardization. And then also we have some other initiatives around international engagement. So establishing a really important forum, the Intergovernmental SEP Network, where we can engage with other patent offices and governments globally to talk about the ecosystem challenges, but also working with jurisdictions, discussions like today is really important as well. So that's another part of our non-regulatory initiatives which we've been taking forward. So in addition to the non-regulatory initiatives, we recognize that actually those non-regulatory initiatives alone won't resolve all the challenges and all the issues which we've heard. So as Andres, as you rightly mentioned, we have launched a consultation, and this consultation really goes to the heart of what we think are the issues, particularly around, as you see, transparency, efficiency, and how do we make sure that we provide better options and improvements around dispute resolution. So I think rather than doing part one first, I'm going to do part two, because I think it's easier to understand the fact that what we want to look at when we talk about information asymmetry is looking at actually what is available and how we can improve on existing information and measures which are already out there. So I think I've just flipped it around slightly. So what we're doing, we're trying to find ways of improving our evidence, and the exercise for the consultation is to gather evidence on potential measures which can improve SEP licensing and dispute resolution. So one of the areas which I know was mentioned earlier too helpfully, but it's in relation to perhaps the idea of a measure looking at whether there is a need to introduce a specific SEP pre-action protocol, or do the existing pre-action protocols around negotiations work effectively. So we really want to understand pre-action protocols, the effectiveness of them, how they're being utilized, disclosure, and how whether those protocols promote ADR and aid efficient resolution of SEP licensing disputes. In addition to the pre-action protocols, we also have a few place questions in the consultation around essentiality checking services. So we really want to make sure that our understanding is up to date. As I said, we launched a call for views back in 2021. Times past, there's been a huge number of new market solutions and commercial offerings around essentiality and provisions of that. So what we're doing, we're asking a number of questions around these, especially to the extent that they're accessible for SMEs, they're costly effective, and they're reliable and trusted. So based on the evidence we receive, we will then deal with the question which we had originally about whether the IPO should decide whether to develop its own essentiality service, or whether we look at other alternatives as well. So it's a really important area, but we need to bring our evidence base up to date. And then the other area we want to understand better is in relation to ADR and remedies in SEP disputes. So we really want to build on our understanding of how the existing frameworks work in the UK. Are they functioning effectively to ensure remedies and disputes are adequate and utilised within litigation? We're also aware of ADR services, including mediation, and they can help resolve SEP disputes. We've heard on the previous panel as well about this, but we actually lack evidence in the UK how much they're being utilised and how effective they are in those disputes. So the questions are there in the consultation for those who use ADR services or provide ADR services to provide us an up-to-date evidence base which we can consider. And then if I then move on to part one, so back to the other measures which we're considering, so the slightly more technical and complex issues, I suppose, which may not require some legislative proposals as well. So we're looking at rate determination. And we know that rate determination is a challenge, and there is a lack of transparency around pricing, and there is issues around certainty. And what we want to try and understand is, are there ways that we could put in place measures which would promote efficiency and dispute resolution, and how we can ensure that disputes are settled in a streamlined and a cost-effective way. And in that consultation, we do ask a range of questions, including methodologies. This morning's session we heard extensively on methodologies, which was really, really helpful. But we do have a set of questions within the consultation which asks for the latest updated information around methodologies for FRAND determinations. But also we ask questions about the rules and the kind of constitution of a separate rate determination forum. So in addition to that, we're also consulting on the mandatory provision of information relating to SEPs. So this is to improve transparency on essentiality around SEP licensing requirements. We're considering whether to mandate the provision, and this is only a consideration. Obviously, we're not proposing it needs to, but also, we want to understand if the provision of information on patents disclosed at SDOs and how that could help at the UK level in terms of certainty, those who want to verify checks at the IPO to see whether this information is relevant, whether the patent relates to particular technical standards. So, this is a function which we're considering to enable users to search and look through the systems as well. So it's really user-centric. It's thinking about those who need to access information at the point that the licensing obligations arise. So there's quite a number of questions. I think there's 47 questions in total within our consultation. We don't do things by half, I'm afraid. And as I mentioned, it's a really complex area. So the consultation, importantly, closes on the 7th of October. And today is a bit of a pitch, really, that those who are interested and can help shape what the UK does in the future of these matters, please respond. We're open to the ideas. Like we said, we put forward principles. What we need is actually, how do we get these principles to work in practice? So we're really looking from respondents to think about, in practice, will it fix the situation? Will it provide more clarity? Does it increase transparency? Does it really help the ecosystem? Even to the fact we're really open to the idea, is it needed? So really, all I can do is encourage those who are here today, and particularly if those are watching online, please do respond to the consultation and help shape the UK's proposals. So last slide, and as you see, I've tried to put some musical notes in there for you, Andras, just to keep with a theme. So what we're doing next, so basically we're going to continue with the non-regulatory interventions and initiatives. So we're really going to continue with looking at the resource hub, the value of that. We've got an exercise which we're undertaking at the moment around the evaluation of the resource hub. We're going to be doing focus groups, engaging with industry, looking what the requirements are, the needs of the resource hub. How can we build on that? How can we put additional case studies within the resource hub? How do we use it in certain sectors to reach out to businesses, new entrants into the standardization as well? So we're looking at ways to improve it and looking at the effectiveness of the resource hub. In addition to that, we will need to spend an awful lot of time going forward looking at the evaluation of the government's consultation on SEPs. So that's going to take us a bit of time. We expect that we will be able to get a government response out early next year. We are pretty statutory bound by the duration. We have sort of 3 months that we have to respond, with some exceptions, but we will have to look at it in pace and provide a position and decision by ministers at the UK on what we do next, basically, on whether we take things forward. Importantly, it's the kind of validation process. So we need to make sure that we do an assessment of impacts of the policy outcomes. They will be that will be undertaken independently, and it will be made public at the point of the government response as well. So there'll be independent verification of what we do. And then finally, we need to think about how we implement our policy then. So once we get a good shape later this year and into next year, and we get some steer from ministers, we'll then have to think about what does implementation look like with the outcomes. I think just one other thing just to mention, that for those who are responding, verifiable evidence is really important. Evidence, as I mentioned earlier, is going to shape what we do. And I think it's really important in this space that we do have verifiable evidence in order to take action. So I will leave it there and hand over to my colleagues, but thank you very much for your time.
Thank you very much, Jamie. That was particularly insightful. And Jamie is also particularly soft-spoken today. So if you have difficulties hearing any of the speakers, you can use the earpieces, because then you will hear it at a much bigger volume. And you will probably, at least some of you will need the earpieces for the next speaker, because Mr. Wei Jiang from SNIPA will be speaking in Chinese. There will be interpretation to all the 3 languages, but then I would like to invite you to use the earpiece and select the right language and volume for you before Wei start speaking. And with that, I would like to turn it over to Wei Jiang from SNIPA, who is going to introduce us to the Chinese practice and future outlook on standard essential patents. Wei, the floor is yours, please.
Choose my speech language. I will speak in Chinese. You may need an interpreter device, and I'm sorry for the trouble. 非常荣幸。
It is my great honor to attend this conference and share my thoughts on the topic of standard essential patents. And now I would like to share China's practice and future plans in this field from 3 aspects. First, China attaches great importance to SEP, and we have also incorporated into our strategic planning to lead its development. We believe patents and standards are both core carriers of innovation, and their integration can enhance the technical level of standards, encourage innovation, and accelerate the commercialization of scientific innovation, expand the scope of patent application. So based on this understanding, China promotes SEP development and incorporates it into a national strategy. In 2021, the outline for building a powerful intellectual property powerhouse 2021 to 2035 explicitly proposed to promote the effective integration of patents with international standards, and the National Standardization Development Outline, released the same year, also seeks to improve standard essential patent system and promote the industrial application of innovations. In October 2023, China issued the Special Action Plan for Patent Commercialization and Application, emphasizing issuing policy guidelines for the coordination of standards and patents, enhance the capability of innovators, and this provides clear policy guidelines for the development of SEP. Second, we adopt an comprehensive measure to regulate SEP development. In China, SEP-related work requires the collaboration of multiple departments involving the Ministry of Industry and Information Technology, the State Administration for Market Regulation, the CNIPA, Ministry of Justice, the Supreme People's Court, etc., etc. In recent years, CNIPA works with the departments I mentioned above to focus on the work in 3 key areas. First, we strengthen policy guidelines to promote reasonable licensing. CNIPA work with these 6 departments to issue the guidelines for the establishment and operation of patent pools, clarifying that patent pools must adhere to the fair, reasonable, and non-discriminatory friend principle, and determine the licensing fee based on the patent's contribution to the product's value, to safeguard the right of all users to obtain licenses on an equal footing. We also work closely to monitor global SEP policy trends, extensively collect intellectual property rules and requirements from major global standard-setting organizations, strengthen communication and guidance for innovators to ensure their standardized and compliant participation in global standardization activities. At the same time, competent authorities have guided the release of automotive industry standard essential patent licensing guidelines, providing reference for the industry to address SEP-related issues. Second, we have also improved anti-monopoly rules to prevent market risks. Anti-monopoly authorities in China have established the provisions on the prohibiting the abuse of intellectual property rights to eliminate or restrict competition, to strengthen regulation of monopolistic practices in standard setting and implementation. We also issued the anti-monopoly guidelines for standard essential patents, clarifying the norms in the SEP field. We also established preemptive and ongoing supervision mechanisms to warn of monopoly risks in patent pool licensing, urging relevant stakeholders to identify hidden risks, rectify problems, strengthen compliance, and maintain a level playing field. 3, we promote cross-departmental coordination to enhance governance efficiency. CNIPA works with other 7 departments to promote effective integration of patents and standards, to enhance the comprehensive SEP capabilities of innovators. CNIPA works with relevant ministries to guide the establishment of patent pools in key areas to promote collaborative application of intellectual property. We actively participate in the work of ISO, PPG, actively participate in revising patent-related clauses of common patent policy, and work on the research of the patent disclosure rules, among others. Third, going forward, we will continue to make efforts to accelerate work in 4 areas to promote SEP development. First, improve the institutional rules to solidify the foundation of governance. We will develop SEP licensing guidelines to standardize licensing practice to prevent enterprises from abusing SEP for monopoly. We will also promote the anti-monopoly guidelines for standard essential patents to guide innovation entities in integrating their independent intellectual property into their technical standards. And we will also work with other ministries to better regulate this field to promote standardization and coordination of policy. We will develop our SEP essentiality review method to make it more standardized and work with anti-monopoly, judicial, and other departments to build a collaborative governance framework. We will also optimize public service to empower market entities. We will work to promote SEP standards database and enable smooth information access, provide SEP licensing and protection assistance for enterprises, enhancing their negotiation and dispute resolution capabilities. And we will increase publicity efforts to raise awareness and promote the high-quality development of the industry with better standards. We will also promote international cooperation and jointly build global rules. We will actively participate in WIPO, ISO, IEC, ITU, and other organizations in the setting of SEP rules, and we will work together with WIPO Arbitration and Mediation Center to provide more diverse dispute resolution channels for global SEP licensing negotiations. In closing, I would like to thank WIPO for providing us with this platform. We will continue to follow the trend of application of standard technologies, strengthen cooperation with international organizations, intellectual property departments, and contribute our wisdom. And we also look forward to WIPO fully leveraging its role as an international organization to promote SEP international roles towards greater inclusiveness and benefit sharing, allowing innovations to benefit people around the world. Thank you.
Thank you very much for these remarks and these explanations. Thinking about 7 government agencies coordinating is quite overwhelming, but congratulations on that. It's very impressive that so many government departments are interested in this topic and that they are working together on this cause. I'm turning now to Chris Hannon from USPTO, and he will provide us with a couple of policy insights in the field of SCPs.
Great. My thanks, Andres, to you and to WIPO, the team, for setting this symposium up. It's a pleasure to be a part of this, and thank you for inviting the USPTO. So I think I'll just begin by sort of recalling an anecdote, I think, before I sort of talk about what the U.S. has done and where we're going before concluding. So I think we all know it's easy to see headlines today, sort of what's at stake when we think about interoperability standards, to the degree of the global race for the next generation of cellular communication, the future of the Internet of Things and connected devices generally. And I want to start by just sort of taking a minute to reflect on what that Internet of Things term really came from and the genesis of that, because I think it's a moment to reflect on sort of where we've been with interoperability standards over the past quarter of a century. So as some of you here may be familiar, the Internet of Things was actually coined back in 1999 by an engineer at Procter & Gamble. And at the time, the engineer was trying to sell his C-suite executives on the notion that you could apply RFID sensors to the supply chain. And so for all of us today, probably that sounds mundane and okay, so what, right? But at the time, it was really quite a groundbreaking application. And recall 1999, the internet was booming, the bubble was about to burst. And to that end, right, there were detractors that said, well, come on, this is impossible. You can't actually expect for this level of devices to be interconnected. Detractors would argue that the limits of physics would constrain the ability to have this much data communicated wirelessly. But of course, as we all know now, sitting here today with possibly multiple devices on us that are connected to the internet, this is in fact a very real thing. And so as much as these, IoT may get thrown around as sort of a meaningless buzzword for marketing purposes or otherwise, I think the implications of the applications, of course, were not to destroy the internet. Radio frequency communication engineers were actually able to overcome those perceived limitations in the laws of physics and continue to this day to expand the throughput amounts that wireless is able to achieve. So coincidentally, as those applications grew, so did the need for wireless device addressing, which gave rise to the open IPv6 standard. So this enhanced addressing scheme actually allowed us to accommodate this new sheer volume of all of the connected devices. And through IPv6, we're actually able to connect more devices than there are atoms on the planet Earth. So just think about that for a second, where we've been. So it's been over a quarter of a century, like I said, since that IoT term was first coined. And I'd argue that the standards ecosystem, if we can call it an ecosystem, which I like to, has flourished since then, giving rise to a wealth of new use cases, new standards, and untold societal and consumer benefits. So today, consumers have access to so many endless array of connected devices, from doorbells and watches and health sensors, thermostats, cars, and on it goes. McKinsey estimates that the potential value of the IoT will grow to $12.5 trillion globally by 2030. So we can all have reasonable differences of opinions on quote-unquote best policies when it comes to patents and standards. It's important to reflect on this thing that we call the IoT and realize how far we really have come and where the global interplay of patents and interoperability standards has taken society. So now, to turn to the theme of this panel, what can governments do in this space? Over the years, we've seen many patent offices in particular attempt to address SEP policy across the globe. So these have included policy statements on remedies, looking at ourselves in the US. Other governments have sought to publish resources canvassing issues in the space with an eye toward small and medium enterprises. We've seen bolder actions like essentiality checking services or attempts at FRAND licensing guidelines. Speaking more broadly, beyond just patent offices, we've seen regulatory attempts flirt with everything from rate setting to essentiality checking services and SEP registries. So while any of these regulatory attempts may have benefits, of course, they also have costs. Thus, it's imperative that any new attempt by any jurisdiction to attempt to improve the functioning of the SEP ecosystem must be data-driven, must be supported by credible evidence, and it cannot unduly stifle innovation. So at the USPTO, our main authority to engage in SEP policy stems from our statutory mandate to advise the President through the Secretary of Commerce on intellectual property issues. So some of the more novel regulatory proposals contemplated by our international counterparts, such as, for example, rate-setting tribunals or essentiality checking services, are inconceivable to us at the USPTO. Obviously, the PTO has a strong interest in protecting and promoting competition across the U.S. and across the global economy, specifically through promoting a strong and effective patent system. Broadly speaking, the U.S. seeks to advance consistent and correct application of enforcement mechanisms under the IP laws. So this, of course, helps safeguard research pipelines, it fuels economic growth, and it spurs innovation to advance economic interests. So with those aims in mind, what has the USPTO done specifically? So I already alluded to our remedy statements. It's important to note generally at the outset that the U.S. approach generally favors a case-by-case adjudication over any prescriptive regulation, allowing the flexibility for courts and other tribunals, as well as parties, to address the facts that are before them. In recent years, together with the Department of Justice Antitrust Division and the National Institute of Standards and Technology, we have issued joint policy statements on remedies for SEPs subject to FRAND commitments. These statements have emphasized that all remedies available under U.S. law remain available, including injunctions in appropriate circumstances, but the courts and other tribunals should consider relevant IPR policies as part of that equitable analysis. The current lack of any formal policy statement from the aforementioned U.S. agencies is consistent with this view. Courts and other tribunals are capable of applying a balanced, consistent, fact-based analysis to take into account all available remedies to facilitate and preserve competition and incentives to innovate. The USPTO believes that this approach best achieves incentives for continued participation in voluntary consensus-based standard-setting activity. The USPTO is also actively watching the standards ecosystem with a view towards these objectives. So as some of you may have seen, recently the USPTO filed a statement of interest in June of this year regarding the importance of injunctive relief for patent owners. While the district court level decision was not specifically in regards to a FRAND licensing dispute, I believe that this audience may find review of that statement of interest indicative of the direction of U.S. policy moving forward. Aside from this, the agency has also been engaged in public consultations, workshops, international dialogue such as this, to gather input from patent owners, from implementers, standards organizations, as well as academics. And through these efforts, the USPTO aims to promote good faith negotiations and avoid anti-competitive, opportunistic behavior in FRAND licensing markets. Consistent with the USPTO's view that regulatory interventions are a last resort, the agency has long championed industry-led solutions. So with that in mind, I'd be remiss not to mention and encourage the establishment and use of patent pools in the SEP arena. The aggregation of complementary SEPs from different holders into a single licensing entity drastically reduces transaction costs and negotiation complexity. Well-managed patent pools increase transparency around royalty rates, questions of essentiality, as well as patent scope. This can be incredibly helpful for small and medium enterprises that may or may not have the resources to secure an untold number of licenses to practice the standard in good faith. So to conclude, the answer to what can governments do, I think will uniquely be constrained by the authority that's in question. For the USPTO, we recognize that standards and patents can drive enormous economic value, as evident from the discussion I gave at the outset on the Internet of Things. Further, we recognize that innovators who contribute technology to standards take risks, and especially U.S. innovators are reliant on recouping reasonable royalties to sustain their R&D efforts. Equally, we recognize that licensees need assurance that they can access standardized technology on FRAND terms and conditions. This delicate balance will require continued cooperation between governments, standards organizations, industry, the legal community, as standards and patents are uniquely a global issue. So with that, I'll turn it back over. Thank you.
Thank you very much, Chris. So sometimes it just boils down to no policy is the best policy. Thank you. And now we'll turn it over to Yoshinobu-san, who is going to present us the guide provided by the JPO on licensing negotiations in the SEP area. Yoshinobu, the floor is yours.
Thank you. Thank you, Andras-san, and thank you, WIPO Secretariat, to give JPO the opportunity to introduce our activities. and thank you for audience to hear my presentation. Yes. So, the JPO have listened to opinions from a wide variety of parties parties such as private companies, IP experts, government organizations, and legal committees about what the JPO should and can do in regard to this matter, as a government agency assigned the responsibility of administrating intellectual property. Then the JPO decided to organize fundamental information that concerned parties should consider when conducting licensing negotiations on SEPs. So this one. This is published as a guide to licensing negotiations involving standard essential patents. The guide is designed to provide fundamental information so that even companies that are not familiar with licensing negotiations on SEPs can conduct negotiations with less apprehension. So please note that this guide is not a rule, not a legally binding document, but a document aiming to provide accurate and objective information regarding SEP licensing. After the JPO published this guide in 2018, in view of increasing discussions on SEPs, the JPO decided to revise the guide in 2022 to ensure that this guide is an up-to-date living document. And the JPO will continue to revise the guide in the future. And this guide is written both in Japanese and in English, and they are available on the JPO's website. And the guide consists of 3 chapters. So this one. So in accordance with our intention of creating the guide, we made it clear the purpose of this guide in chapter 1. The guide is aiming to enhance transparency and predictability by providing appropriate information concerning licensing negotiations objectively based on the court case judgment of competition authorities and licensing practices.
Yoshinobu-san, you see your slides over there, so you don't have to turn around all the time.
Yeah, thank you so much. And we believe that it helps facilitating negotiations between right holders and implementers and prevent or quickly resolve disputes concerning SEPs. This guide does not present recipes that can be used in negotiation to automatically calculate appropriate royalties. Rather, the guide is meant to summarize factors that concerned parties should consider when conducting licensing negotiations. And this guide is subjected only to FRAND-encompassed SEPs. We understand that there are 2 aspects of FRAND. One is the negotiation process itself, and the other is the terms of license. Our guide's chapters 2 and 3 address each of these aspects and identify points that each party should note when performing the license negotiations of SEPs in terms of license negotiation methods and royalty calculation methods. Those parts are based on more than 30 case laws in Japan and other jurisdictions, and more than 50 comments of experts from all over the world. So I will explain some main issues introduced in these chapters. So firstly, in chapter 2, this guide refers to the framework of good faith negotiations indicated by the CJEU in the case between Huawei and ZTE. We regard this framework as a useful approach to encourage good faith negotiations, whereby right holders may fulfill their FRAND obligations and implementers may minimize the risk of the injunction. On the other hand, this framework does not provide specific details about the negotiations, such as the scope of information the parties should provide and the response period at each stage of negotiation. So we listed more specific issues relating to actions that parties may take and should not take at each stage. Based on court decisions by various countries, actual practices and the norms established by the governments. So, aside from good faith negotiation, in front-based negotiations, its efficiency is also important. In this guide, we summarized opinions from both SEP right holders and end product manufacturers, and listed some standpoints to consider for efficient negotiation, such as number of players involved, exhaustion and double earnings, and sharing the burden of licensing fees. And next, regarding Chapter 3, the main issue is royalty calculation. Our guide sorts out the factors to consider in determining the royalty based on standard practices and past court cases. A basic approach to determine reasonable royalties involves determining royalty base and royalty rate. In terms of royalty base, it's an example of a chip, but our guide shows an approach to determine the calculation base by judging whether the contribution of the essential part of SEP technology is beyond the chip itself. For example, it supports the operation of functions of a device larger than a chip, or it is confined to the chip itself. Our guide also introduces approaches to royalty rate determination. Our guide shows two frequently used approaches in court decision, bottom-up approach and top-down approach. So, and please note that this guide does not direct to determine a specific royalty rate or amount. And we believe that royalty rate calculation methods should be determined flexibly by the parties on a case-by-case basis. And the last main issue is non-discriminatory royalties. And our guide introduces arguments from both sides and relevant court cases so that negotiating parties can easily recognize and understand this issue. And the next slide. And next. So additionally, I would like to introduce the difference between guideline from METI, Ministry of Economy, Trade and Industry, and the guide from JPO. METI publishes the good faith negotiation guidelines for SEP licenses, so in 2022. As a background to publish the METI's guidelines, there was an idea that the non-existence of clear rule for negotiation decreases the predictability and transparency of negotiation and causes some issues, such as business risks and burden of trial for both sides of stakeholder and implementer. And the existing JPL's guide provided information of both sides of the argument. So the additional guidelines were needed to make clear what kind of approach is regarded as good faith negotiation. The METI's guidelines specify the actions that both parties should take in major 4 steps of front negotiation dance. So, and step 1 is licensing offer from SEP holder. METI's guidelines specifies what kind of information should the SEP holder provide. And step 2 is expression of willingness to conclude a contract under front terms from implementer. And METI's guideline specifies what reaction should and can the implementer take. And step 3 is a proposal of specific license terms from SEP holder. METI's guideline specifies what kind of information regarding license conditions should the SEP holder provide. And step 4 is proposal of counteroffer from implementer. METIS guidelines specifies what kind of information should the implementer include in the counteroffer. So in summary, METIS guideline provides the norms of good faith negotiation to be followed by SEP holders and implementers involved in SEP licensing negotiation, including Japanese patents. So, and JPO's guide is not the norm. It objectively summarizes issues concerning licensing negotiations. So, and both are not legally binding and does not forecast future judicial rulings. So that's all for my presentation. Thank you.
Thank you very much, Yoshinobu-san. It's very good to know that not only the JPO is issuing guidelines, but it also regularly updates it. And it was also very insightful to learn about the differentiation between the METI guidelines and the JPO guidelines. So thank you for that. And last but definitely not least, I would like to turn to Alfred, who is going to present us the Singapore approach. What does IPOS do in the field of SEPs? Alfred, the floor is yours, please.
Thank you, Andres. I should warn that it's a little bit dangerous to give Asians a handheld microphone because of our love for karaoke. But don't worry, I'm not going to be singing today. But with the theme of a September symphony, the temptation is real. Yeah. Speaking of music, it feels right to mention that 2025 this year marks the 30 years of when MP3 was born. Technology, I'm sure all of you will agree, has revolutionized the way we listen to music. At least for myself, I could recall bringing around a CD album. I'm not sure if any one of you remembers what that is, so that I could access the tracks, my favorite tracks, while on the move. Today, we stream music from our phones. We text our loved ones the moment our plane lands at the airport when attending meetings like this. All these everyday conveniences is only made possible because of standards that enable technology and devices to work seamlessly together. So where are we today? The top 30 SEP holders account for over 90% of declared SEPs. So about 2/3 of these SEPs are filed at IP5 offices. And if we zoom into ASEAN, you will realize that the filing patterns are pretty similar in that the top applicants are largely the same global players. So that goes to show the global reach of standardization as well as ASEAN's alignment in terms of worldwide technology adoption. In Southeast Asia, Singapore remains to be one of the top jurisdictions where SEP holders seek protection. This is followed by Malaysia and the Philippines. Just earlier this year, the LESI hosted its annual meeting, and I believe some of you were there. The theme for the conference was Smart Cities, Smarter IPs. This is timely because as cities become smarter, more connected, the need for fair and transparent SEP licensing becomes ever more important to foster innovation and result in economic growth. When it comes to SEP matters, Singapore tends to take a more balanced approach. We tend to consult the enterprises, and through a study that we recently conducted with the LESI, and this was through gathering inputs from a very diverse group of over 60 participants, it was affirmed that government still has a role to play. And from this, we frame 3 key themes. Right? The first being building enterprise capabilities and awareness. The second relates to ensuring trusted regimes. And the third is about fostering collaboration. So first, enterprises. Through our engagement with the enterprises, we realized that the awareness for SEP remains pretty low. In Singapore, we tend to take a whole-of-government approach when engaging the industries, either directly or through the government agencies. Just about 2 weeks ago, we presented some of our preliminary findings of our report with the members of the Singapore Standards Council. And in that meeting, it was not just about presenting our findings, but also listening to the challenges faced by the enterprises. And we feel that this two-way dialogue is critical because governments can't create effective policies without understanding business realities. At the same time, the industry may find it more challenging to navigate SEPs without clarity from regulators. Then, aside from these resources, we find that patent pools also could make a difference, right, to SMEs. But Chris has already mentioned some of these benefits, so I will not belabor the points. The second theme is on trusted regimes. And the SEP conversations tend to circle around transparency, or rather the lack of it. For instance, in areas such as royalty rates or essentiality. Take the 5G standards, for example. In a recent report that was published by Clarivate, it was noted that there were nearly 500,000 patents that were declared essential to these standards. Now, the question is, how many of these truly are? The claims might evolve from the time the applications were declared essential to the standards to the time it was granted. The scope of claims across family members may vary in jurisdictions, resulting in some to read on the products and services, but not the others. Then some of these claims could even be anticipated at times by disclosures at standard meetings. That is why IPOS ensures that our patent examiners are trained to not just search within patent databases, but also SDO repositories to ensure there's a robust prior coverage. And the access to these documents are absolutely critical, and that is where we feel that by having access for the patent examiners worldwide, it could increase the quality of granted patents. This is an area where we feel that the governments could perhaps work more closely with the SDOs. While standards are global, because standards are global, the disputes that revolve around standards tend to be entangled in geopolitical rivalries. So where do parties go? Neutral venues with strong technical and legal expertise. This is where Singapore offers venues such as the WIPO Arbitration and Mediation Center, the Singapore International Arbitration Center, Singapore International Mediation Center, as well as our Singapore International Commercial Courts, all of which are supported by highly qualified judges as well as IP specialists, such as my fellow comrade Chung Lien, who was speaking at the earlier panel. But then we realized that some MNCs do prefer to work with institutions that they are more familiar with. And that is why we welcome institutions such as the AAA ICDR, the ICC, as well as the Permanent Courts of Arbitration to establish offices in Singapore. And throughout the process, parties retain the flexibility to appoint their own arbitrators or mediators. And this reinforces the trust and confidence in the entire process, because after all, neutrality is not just about geography, it's about setting up systems that all parties trust. And the third and final theme relates to fostering global collaboration. SEP issues are new. As the world becomes hyper-connected, as more machines start speaking with one another, interoperability becomes ever more important. Yet jurisdictions can't resolve these challenges alone. So when Andres and Nina shared that WIPO was organizing this inaugural symposium, it was music to my ears. I was excited not just because Singapore had the opportunity to share our perspective, but also to be here to listen, to learn firsthand from the fellow officers as well as stakeholders from all over the world. Because policymakers can't create regulations in silo. Engagement is key, not just at home, but globally. So where do we go from here? Right. At the heart of all SEP conversations lies something deeply human. And this was mentioned by several panelists in the earlier sessions, as well as by Jonas earlier, and that is trust. With trust, SEP innovators and implementers can find common ground. With trust, It can strengthen partnerships between government and enterprises, and underpinning the trust relationships. So let's not forget that the connections are not just built at formal sessions like this, but also at receptions or dinners. And this personal ties, fuel collaborations long after we leave Geneva. Yeah. So let me end with this, a quote from the opening lines of the song, Try to Remember. It was first performed by Jerry Orbach in 1960 at the musical called The Fantastics. I'm not going to sing, but the lyric goes, try to remember the kind of September when life was slow and oh so mellow. Try to remember the kind of September when grass was green and grain was yellow. It is a song about nostalgia, specifically the act of recalling the simple and tender times and also the emotions that were associated with it. So if you are ever find yourself in a tough licensing negotiation and frustrated with the parties across the table, I hope you'll always remember this September, the conversations we had, as well as the connections we built at this fabulous symposium that is put together by Andras and the team.
Thank you very, very much. Those were perfect closing lines. But let me just flip the old conference joke around a little bit. So the only thing standing between you and the cocktail reception is not us, but your questions. So we have 5 more minutes to take a couple of questions. And I saw some particularly mean ones, so we are not going to take those because we want to safeguard the September mellowness that Alfred was advising us to do. And let's focus rather on coordination and collaboration internationally. So the question is, and this can be taken up by any of you, how can IP offices and policymakers coordinate more effectively to reduce fragmentation in the SEP FRAND policy or policies across jurisdictions? And this is particularly relevant to us because we are sitting here at WIPO, and we would also like to see such coordination and such collaboration happen. So apart from hearing from all of you what your respective governments or institutions are doing or have been doing, we would like to hear a little bit more about how would you like to reach out to each other? How would you like to coordinate more what you are doing in the policy space? So maybe just in 1 minute, I would like to hear one thought from each one of you.
Well, actually, it struck me earlier when the economic colleagues presented their thoughts on FRAND methodologies, FRAND determination methodologies. I think that's something that WIPO is producing, which I imagine can really be the fruit of much more international agreement. Because I believe that if we have some form of agreement on the methodologies to get to a FRAND rate that has, sufficiently trustworthy evidence base, then I think that can really be the fruit of more international collaboration across jurisdictions. So my view is that much of what you're asking is basically what you're already doing and what is going to happen in just 3 minutes' time when we have cocktails together.
Thank you, Jonas. Really, how do I add to that? So, yeah, I think it's a really important point. So, how do IP offices and policymakers coordinate? And I think we do, and we're doing it now. And it's early days, and something which we have been reflected on in the UK as well. It is certainly early days, and it's hard work coordinating across countries. The team in WIPO, you're doing it well, and I think you do have a role to play to do that. But also there is complexities within the SEP landscape, and something which we talk about at the Intergovernmental SEP Network as well is because the complexities around the competition frameworks, around the government strategic kind of approach to standardization and SEPs and the value of that for certain jurisdictions. But also, there is contract issues, the patent law issues. It's not easy. It's not easy in this field, but I think we are trying. That's why I want to say we are trying. It's early days, early doors. I think we've got some ideas where we can start collaborating further. just mentioned earlier, and I saw someone's comment about the US UK MOU and what we do to work together. Early days. I think when we signed up these things, there's been things in the background which we haven't been able to deal with because it's outside of our control. But it certainly is high on our agenda to make sure that we find the opportunities to engage using these forums, using other forums. And I think myself and the team, we spend an awful lot of time reaching out to different contacts around the globe almost every day on these matters, but it just takes time, and as I said, it's early doors to that.
Thank you, Jamie. Right?
我想从
Well, I would touch upon 2 points first. Domestically, all government ministries are collaborating very closely. I already said in China, different ministries are trying to promote the healthy and stable development of SEPs. The anti-monopoly authorities, they are actually trying to stimulate the antitrust behavior. And the Quality Supervision Ministry, they are trying to regulate the service providing, but the Ministry of Justice is dealing with judicial issues. But of course, so they have different remedies actually, but they are all trying to promote the development of SEP. The second part is the international or global cooperation. Just now, we learned the practices from many countries, be it from the policy or from the legal perspectives. We think WIPO has provided such a forum today. This fact itself has already given us, the policymakers of different countries, provided a very good platform for us. So actively participating in such discussions is very good. Through such platform, we can deepen our cooperation with other countries. Thank you very much.
Thank you very much. Chris?
Yeah, I'll be very brief. I mean, I just think the concept that there could be such a level of fragmentation to the point that there creates this divergence. I think we should all nations should be operating with this respect that this is a global situation that we're in, and to the extent that we have fora such as this to communicate what evidence we have, what sort of objective things are truly happening that would require some sort of intervention. And obviously, it's very complicated because, as is alluded to here, there's competition concerns. But speaking purely from a patent office perspective, to the extent that there could be such a grave failure in the marketplace that we see that differently, I feel like that wouldn't exist, and we should all be continually conversing about what these issues are so that we can address real issues. Thanks.
Thank you. Let me remind all the member state delegations here that we do have a standing committee on the law of patents, so I would encourage conversations among member states on standard essential patents for sure. Yoshinobu-san.
Thank you. So I think this symposium is the answer for me to the question. So JPO usually collects all information to make new policies. So I think the knowing each other is the key point for us.
Thank you very much. Alfred, do you have some more beautiful words for us in closing?
Well, I was just going to say that the SEP is another excellent forum because that is where much more member states participate. And as Andras shared this morning at his presentation, the topic of SEPs has been revived recently by a proposal submitted by the Canadian IP Office. So that's where a lot of conversations, coordination could take place. But more importantly, I'll go back to my point in that the coordination, the collaboration, the ties last beyond the formal sessions, right, that we have, and outside of the meeting rooms. Yeah, I'll just end with that. Yeah.
Thank you very much. It was a great panel. Thank you for all the participants in the panel and the audience for the patience and also for the interpreters for the overtime. Thank you very much. Give a hand to the panelists.